Okay, we can begin the meeting of the Subcommittee on Board Rules and Procedures. We have 3 items on our agenda today. First, Madam Secretary, would you read the roll?
We really don't have to do it.
Oh, okay, we don't have to in subcommittees? Fine. Then you know what? Let's streamline. we could do that. The first item relates to the consent calendar. I think we have 3 new members since the Subcommittee on Rules originally had asked that in order to streamline the agenda, we have just consent items as opposed to special consent, which always seem to be appeals and take a very long time, and regular consent, which hopefully is literally consent, and we can vote on the entire consent calendar at the same time. I gather that OPSC has requested that we relook at that and reinstitute a special consent.
It was Senator was requested by some of the members of the existing board that they would like to bring this item back for discussion.
Okay, and are those members here today? You want to try to fix it again? We lost our little microphone. Yeah.
Senator, if we have to board the Simmons side and start destroying our equipment, we're going to start taking it out of the senator's budget to fix our outdated equipment here.
Oh, dissension already.
So, yeah, we did have a member that's actually present that actually requested that the item be brought forward to the Rules Subcommittee. And that member is a representative, Kathleen Moore. Yeah.
I believe I probably did talk about this, and I'm glad that it can be brought back to the board or to the subcommittee. And all that I was indicating is that it appeared that our consent specials that were considered separately seemed to be added into our consent items at most of our board meetings. So I was wondering if it's something that we continue to need to have separately, or is it one that the consent specials would be also considered as part of the consent calendar? And I'm open to the discussion either way.
Mr. Hagman?
Thank you, Madam Chair. And I agree. I mean, a consent is consent. Staff recommendations, I think any of us can pull off anything off consent that we don't have, that we may have an issue with as far as recommendations from staff. So lump it all together, get it out of the way, frees up a lot of the audience if we know we take it out ahead of time. I don't really understand the difference between the special consent and regular consent anyway, besides there are different categories of consensual items. So if you're looking for any kind of motion, I would say group it together as one big list, and we saw the same rules apply. We can pull them off if we want to.
Is there any advantage to the staff to have the special consent?
I think it's obviously, as far as organization, it would still be the same. We would still tuck it in. If we wanted to have its own separate tab within the consent special, I think we can accommodate that. So that way they can stand out from the rest of the consent agenda. I mean, it's really not that difficult to do.
Okay. Madam Chair, if I may, I think and this came out when I became the chair, there was an apprehension of approving some items that were appeal and action items outside of the regular traditional consent. But there were items that issues had been resolved, or there was no way we're going to vote no again, or we're going to vote against the issues. So I asked that if it could be put in consent, and I was told that traditionally it had not been part of the consent. So then we started sort of adding tabs 6, 9, and 12 as a special consent because it wasn't part of the consent. But I think that there's a little bit of distinction in the traditional consent and the other items that get added later. And the traditional consent is stuff, the bread and butter stuff. The special consent items, and we can put them into consent. I just want to make sure that we recognize that those are items that are in tabs 5, 12, and 13 or whatever, and then we can just roll them into part of the consent, but you still need to have that separation because there's more detail, more documentation. And if a member does choose to pull that item, then there's that historical tab that you want to have and refer to versus the index and so forth is pretty generic. I mean, we're not going to pull item, Driftwell Schools 750 for the new Windows item, followed by the Port Hueneme 254 walkway kind of stuff. I mean, that stuff is going to be part of the consent regardless. That's the only thing I had.
But you can have it categorized. That's what we used to have on the city council level. This was Park and Recs, this was building engineering. They were separating categories. That's what you're saying with the tabs by consensual items, but still all in consent.
Yes.
Yeah, I think I agree with Mr. Hagman. Use of the consent calendar, as I have always experienced it, as I believe we do it in the Senate and the Assembly. Well, actually, they're a little different, because in the Senate and the Assembly, there are items which we know in advance, no one has objected to, right? In local government, we used to put as much as possible on the consent calendar, because there were things that might actually look somewhat controversial, but in point of fact, everybody agreed, and there was no point in hashing it over for half an hour. So recognizing that items can and will be taken off the consent calendar if the body does not agree to have them passed, it would seem, I really feel that letting it stand the way it is has worked quite well for me, at least.
Stand the way it is,
Leave it
meaning
alone.
We're suggesting to bring tab 6, 9, whatever, into the front section of the daily business under consensual items.
Consent. Okay.
But you could have categories on those consensual items, say administrative, whatever tab 6 name is, have it like that categorized under consent, but one master consent calendar itemized by subject. Right? So that's
Madam
recommend-
Chair, when the subcommittee first chose to remove that special consent tab, that's what staff did. We put those items, and again, these items are your typical facility hardship, health and safety issues that not standard applications, but they're a little different. And in the past, the board members did want those to be highlighted. So what we did is we put them at the back of consent, the consent agenda, to try and highlight them for the board members and staff. And at that point, there were some comments that were made, well, sometimes we don't know that they're back there. It might be better if we just pull them out of consent, put them as action items so that they can highlight it. So that's something that we did originally. We can do that again. We can create a separate section of consent and put them in there. It's up to the subcommittee.
So by changing it, are we adding work or
No.
No.
simplifying?
No, just a different section on the agenda.
So would we have a consent specials portion of the consent calendar, is what you're
Yes.
what you're saying?
Yeah.
Right.
And that is, that consent specials could be removed from the consent calendar should a board member want to, versus what are we doing currently? We have it, just each item stands on its own?
It's structured as part of the action items.
Yes.
Or they can be structured as part of consent, because if nobody takes them off,
Yeah.
you don't have to deal with it. I mean, to me, it's very confusing to have consent and controversial consent.
Yeah.
Let's either make them consent, and if somebody wants to pull them off, they can, which is what we have now, or put them in action items for discussion. Nobody else that I've been able to see anywhere has a category called special consent, which seems to be an oxymoron, really.
Right.
And, if you want to call it a different name, like hardship cases or controversial, but then they go into action items.
Yeah.
So,
It's consent.
No, I
or
think you're
action?
consent.
Yeah.
I think you're absolutely right, Senator. Is it a consent item or is it an action item? And I think that the only reason why we came up with this hybrid is that people didn't want us to add those non-controversial action items to the consent. And it seemed that it was silly to have people come in and talk about the issue that everybody was on board. So then we came up with, okay, let's pull this, and when I suggested that we put it to consent, they said, no, people pulled it from the consent. So, well, can we call it a special consent? How do we, and then members started saying, okay, I move consent and include items, tab 4, 3, 9, and 12. And so that was another way around it. But I concur with you 100%. It should be part of the consent item. It could include the description, the information. If people want to pull that item, that can always be pulled, and the action taken appropriately.
And the public can pull anything off. They agree
Right.
request at the beginning to pull off any kind of information off the consent calendar as well. So we're just going to have one consent calendar. You could and you can put as many different titles you want underneath it, but there's one consent agenda, then people can pull it off as needed.
Administratively, that should be able to be done.
Do we need to make motions or anything, or just recommendations?
Well, if we keep it the way it is, we probably don't need a motion,
No,
right?
we do, because it's not set up that way right now. Right now, we have three
Right now,
categories.
we have the special consent nonsense.
Oh, we do have it.
Yeah, we have a
I thought we
spe-
did away with it. No?
They're called the action items currently. So the consent specials moved over to what we consider now today action items. The board did adopt that change in 2010.
So we want to move it to where,
To where the special action items for which there is consent to be rolled into the
Okay.
consent item.
Okay.
And I think there's a motion by the
and I think
committee to do.
administratively, it'd be between the chair and the staff to put those items on a consent. Those members, the rest of the board members have the right, when they review it, to pull it off either before or during the meeting before we vote on it.
And these are for items that our typical staff has to bring before the board, and there's consensus on. But for items that are appeal items would still be in the action items of the board, correct?
Correct.
Correct. The appeal section, right. They have their own separate tab, the appeal
Yeah.
section.
So have a consent and an appeal section.
What happens when you do have an appeal, though, and you're bringing it up to the board, and from conversations with the board, the chair and the vice chair, we all agree that, yes, you're not authorized to give them that, but the board clearly will roll staff. Would that still be part of consent, or would
Appeals.
that be part of the appeals?
Right,
But the chair still has a discretion to add it as part of the consent, just like we've been doing now.
right.
You can make a motion, but keep it under the appeal section, and then if
So
you
you
make
would
a
then,
motion just to move it or to move it to the consent, it'd be the same amount of effort
so then Mr. Hagman would move the consent plus tabs 7 and 9.
if they wanted to, yeah.
Okay.
Okay, should I ask for comments from the public? No comments from the public. Mr. Hagman, would you state your motion again, please?
That we eliminate the special consent section, and that the chair and the staff can put nominal, normal consent items on one master calendar, whatever subcategory and tabs they want inside of it. Is that
Okay, is
clear
there a
enough?
second?
I'll second.
All in favor?
Yes.
Opposed? Okay, motion carries unanimously. Item 2 is appeals. And I guess we have a number of choices here. My understanding was that this really was a request from some of the school districts that would like us to have a clear 6 votes to either approve an appeal or deny an appeal. And so I'm wondering if staff has any comments about that. Well, Mr. Hagman does, okay.
I always have comments.
Okay.
I looked at this section yesterday, and it came up we've had 1 or 2 instances I can remember where we have been a divided board on whether to take action on an appeal. But let's take the definition of what we're doing with. Over 99% of the business done by the SAB board is done administratively by staff. They follow the rules that we put in place. It's pretty black and white. The problems when we have is when people want to appeal the decision of the staff recommendation. That means an action has already been taken. I think there needs to be consensus, whatever number that is, a majority of the board, whatever, to overtake an administrative action. So a basic appeal says, I don't agree with staff. I'm going to take it to the board and plead my case with them. And the board then has the right to overturn, hopefully within our legal boundaries of following our own rules, But that's what the appellate process is. If you have to, because we came to that point where we had motion A, B, and C, where we could not get 6 members on a decision, all agree upon the same action to take, of a different action. But there already has been an action taken. So my feeling is that it takes 6 votes or a simple majority of the board to overturn an administrative action. Otherwise, the administrative action should stand.
So you're saying, yes, we should have 6 votes?
Just to overturn,
To
not to
overturn.
affirm.
So,
Okay.
so I concur with Mr. Hagman that the original decision, when the first allocation was made, that was when the board took an action and provided the resources to do what they're going to do. The appeals generally come back because they needed to do something differently. They did something different. They want to change the scope. And from my perspective, I think the staff has looked at it and said, no, this is not something that we can approve. So to change what you want, to change to what you want to do, it has to go to the board. And it's at that point that the board has the option, as Mr. Hagman points out, 6 board members want to overrule staff, or the staff's decision stands. I think to require that 6 votes to support the staff's decision is sort of, it doesn't make sense.
And then what do you do if you don't redo it? Like that one
Yeah.
situation, that means the thing's in limbo forever. I mean, again, 99% of our business is done administratively. We're here to approve the exceptions to the rule. And so it should take a majority to do that.
Right. Administratively, the program makes probably hundreds of decisions a year on applications. And I would imagine that many of those decisions, a district may not completely agree, but strategically they'll decide which one they want to appeal, in the belief that they have a good enough case for the board action to overturn a staff decision, a program decision. So if we made this change, potentially every single denial is up to the board, and if there isn't enough votes, then every single case could be overturned and go towards, in favor of the appeal. How many potential appeals do you think there would be?
The margin's very small.
Last year, in 2011, we had 13 appeals, excuse me. We had 406 projects that were approved in consent for a total of $1.1 billion. The 13 appeals equal to about $12 million.
Right, but those were appeals that required at least 6 votes for the action to overturn.
That's correct.
But if there weren't 6 votes, that's what we're saying now, then the administrative decision wouldn't stand, would be reversed?
No, what you're saying is that the administrative decision would stand, I believe, is how
No,
the discussion was
because if it
going.
requires 6 votes either way, and you don't get 6 votes either way, what happens?
Then it
Right.
would just sort of drift from month to month in the agenda,
Right.
right?
Well, here's how I've seen it, how we operated at one time as a board. The staff made a recommendation, and sometimes that recommendation was deny the district's request. Sometimes that recommendation was an alternative option to perhaps what the district is asking for. As I understand the write-up here, and the recommendation by staff is that they would not take a position. There would be no recommendation. There would be options for the board to consider. And if the board did not approve one of the options with 6 votes, then the administrative decision would stand. That's how I understand it being presented to us. And I guess I have an opposing viewpoint on that, in that we have had that tradition, which actually in the past required that if there wasn't a vote to either approve or disapprove an appeal, that it went back to staff and to the appealer, the school district or county office or charter, whoever was the appealer, to bring forth a item that would be that would get 6 votes, potentially. So it could be that it was in, as you call, limbo, until such time as that was brought forward, but that we moved to this issue of, at first there was an take no action, which meant that, which was confusing. And I think that it was represented in here, and I know I spoke with the person, Jeannie, who represented us in that January meeting. That was her belief, that it was confusing, this take no action. And so she wanted this discussed, I believe, and she actually said there should be an action taken. So I think there's a couple of things we're being asked to consider here. One is that on appeal items, that there will be no recommendation of staff, that they would bring forward options, and an option would require 6 votes in order to proceed. That's one consideration. And then the 6 votes, I think, on the appeal in order to proceed on an approval is an option. And then what's being not recommended is that there have to be a vote on the other side of that. If we don't take a vote, or if we don't take a vote negatively to deny an appeal, that it is in a different state. So I think there's really 3 issues before us. And the first, starting with, is it such that the Rules and Procedures Committee would recommend to the board that on appeal items there's no recommended action by staff? That seems to be the first item that's changing. And then from there, the others.
Can we take one at a time? Under that scenario, I mean, every board item we have has a recommendation from staff. They may have options to go on top of the recommendation, but a lot of times it's been recommended by staff because they administratively took the action to deny something. That is their base recommendation. Otherwise, they wouldn't have done it. Now, they could say, under the rules or existing criteria, the board may overturn our staff decision, and these are the options you have as a board to overturn a decision. But a recommendation has been clearly made. I mean, they've done so administratively. That's why we get the appeal in the first place. That's different than them coming up to a situation they don't know how to handle and seeking guidance, which would be another discussion on. But when we're talking about appeals, the decision has been made, recommendations have been made, and they may or may not give us options based on the law that says you can go this far or this far, and the recommendations based on those options, even with for example, if they want to put option A would be the school district's appeal, why they want that, and that's their case, and then obviously they have to write the conclusions. Sometimes it leads to legal brief. We don't have the authority to do this because of this section of the code. The option B is you do have this leeway because these are the parameters of the code that gives you, but obviously our recommendation was no because we denied it in the first place. And then, those are the different options they give us. It's not so much a recommended option, just more of what's kind of giving us the legal path that we could take. But I think the action's already been taken by the time that point's happened, and that we need an affirmative vote to take another action. Doesn't mean we have to necessarily decide that day. We could come back and say, well, you gave us A, B, and C, but we came up with D, and no one clearly could say if we can or cannot do D, but that seems like the consensus. Can you bring it back to us next month and see if that works out? I mean, we've done that before. But it still takes a action to reverse another action that's been taking place.
Yeah, I would tend to agree with that we do in fact have a staff recommendation. The staff denied the appeal, right? In the staff report, however, I think they may want to bullet for us, highlight the reasons for the denial. That's the recommendations. Mm-hmm. And then it would take 6 votes to approve the appeal. Mm-hmm. Which would, right, or approve the appeal in some form. What might be helpful, instead of options, which as I recall got very convoluted and complicated, there's something that they do in the staff analyses that we get in the Senate and the Assembly, where the committee consultant tactfully says, the committee may wish to consider, and then they offer some amendments. And if I would like to know, for instance, when we're given a denied appeal, and is is this something where we would need to change regulations were we to decide that the interests of school children in California wanted us to grant that appeal? Would we need to have a change in law through legislation? Or would there be something that occurs to staff as a compromise action with the district? If they didn't ask for this, but they only asked for that, we would recommend. I don't know if that's too complicated, in which case I would think just the reasons for denial and an indication of what would have to change.
That's the thing that I think that we can do, Madam Chair. One other thing that I wanted to highlight is there are cases where staff denies a certain grant amount. The district then appeals. It moves over to a different section in our office, and that section reviews the appeal, and we do have administratively resolved several appeals.
Yeah.
So sometimes you may not see appeals that come before you because we do look for ways to try and resolve the issues. In cases where it may be a question of a regulation change or potentially a change in law, and that's the basis for our denial, we can highlight that in our item and the reasons why we denied it. But I just wanted to point out the fact that staff does try to resolve, and we do resolve these appeals administratively.
I applaud.
Yeah, and I think,
I think it's a
you know,
great thing to do.
I was going to report on that one. As the chair of the board, I actually end up adjudicating some of these with the interested parties and staff and trying to figure out, you know, yeah, well, maybe that sidewalk didn't work, but if it were a driveway, it would have, and those kinds of things. Or if you take this piece and agree not to take this piece, would everybody go away? And so a lot of that goes on throughout time, and there are folks in the audience who can say, yeah, we do that. And so a lot of those appeals we actually never see because that stuff gets resolved. The problem, as you point out, Mr. Hagman, comes up when we had a recommendation at the time. Folks wanted recommendations, and the recommendation was deny as one option. The other option was to approve, and we couldn't get 6 on either one of those. And I agree with you, Senator. To have this in limbo, we can have several just sitting there, and for several weeks we would have that issue pending. So I think that would be a concern. So I think the hi, how are you? They have your name there. It's okay. You can sit with me. So I do think that, you know, the items you're pointing out would be helpful in terms of what the reason is, and I think that's included in the report.
That's usually included in our report, the reasons why we can't approve something administratively. So it is part of the staff discussion. It may not be listed bullets format under the recommendation, but it is part of the staff report. And we do highlight some of the challenges when we can't get there completely, and it may require a reg change, and I think we've done that in several cases. So I think we do our best to try to highlight where our challenges are, and that's why we bring these items forward for the board direction.
I think for many of us who can be time and attention challenged, it would be helpful if, even though you put it into the staff report, you know, one of the reasons we re-looked at the rules was that we were spending so much time trying to read and decipher, honestly, very administrative language, that just the staff denied for 1, 2, 3 reasons. And even if you've given it 3 paragraphs somewhere else, that would really help us, and if we had questions, we could check back. I just wondered if Mr. Savage had any comments based on what you do with the imp, whatnot.
Well, I think that probably one of the most important things that we hope the subcommittee will deal with is, and that part of what brought this up, is that we should not use the take no action approach, and that's one of the, any of the options that are here would get us away from that. Well, the first option still has it in it. It states take no action, but I think it's important that that's really, we want the board to, by taking an affirmative action to overturn the staff's administrative action, they would approve an appeal. So if you go to page 6, either option B or C, I think it's the take no action portion that's caused a lot of the issues, just in terms of how can the board
Thank you.
affirmatively take no action? And so I think that seems like something, the major thing we'd like to take care of. The second thing that I'd like to point out, too, is that, I'm sorry.
Well, no, I mean, take no action. The board took an action when it first approved the grant. And now there's an appeal, and staff is saying, we don't approve the appeal. So the take no action, are you suggesting that the board, I mean, obviously, if the board is going to side with the district, there is an action. But if the board is going to side with the staff, are you suggesting that the board has to take a 6 vote?
No, that's not what I mean at all.
What does it mean?
We've had recommendations recently, or within the last year, that have included the statement in the recommendation, take no action. And I think that I don't think it's appropriate to see the language, take no action, as part of what somehow the board is affirming. That's what I'm trying to say. And so by taking no action effectively, but not voting to take no action, that's, I think that's what we need to get rid of, is not to have that language included, even if by effectively not taking an action to overturn, they affirm the staff's action by not voting to overturn. I understand why the language was there, but I think it's what's part of what's caused the confusion.
So the school district of Savage has come before us, and they made the appeal. And there's no motion and there's no second.
So the board has taken no action, and so the appeal will not be overturned, but the board hasn't been asked as an,
Oh, got
or
it.
given
You don't
an
want to
option.
see it in the narrative.
I don't want
There's
to.
no I got it.
I think
Okay.
that's what's confusing, yes.
Okay, all right, I'm tracking
That's all I'm
what
trying
you're
to
saying now.
So
Okay.
you're are you saying option C? That there has to
Option
be
C is
6
a very-
votes to approve the district's appeal, and if there are not 6 votes to do that, the administrative decision stands.
Option C is to me, is a very clean option. But I do want, can I comment on option B, that the item, option B, that says seek board direction? In my limited experience here, I've found that when staff has presented an item and said seek board direction, they've often used it in a way that means that we, administrative staff, may not be able to approve this, but it may have extenuating circumstances that the board could easily approve. So a good example is the FedEx missing the deadline due to the FedEx when the rioters occupied the center of Los Angeles. And so staff doesn't want to approve missing a deadline, but they can see that there are extenuating circumstances, so they might label it as a seek board direction. And so I think this gives some flexibility for the board, for the staff, and for school districts. So something to think about.
So that would actually be, as we were saying, the staff would state the reasons for denial. They would have the option of suggesting that there might be mitigating circumstances that the board, at its discretion, could legally enact, or that you'd have to change regulations or change laws or whatever to make this happen. And those could be presented as part of the board recommendations. One of the reasons we need we need recommendations from OPSC. And then it would take 6 votes for the SAB to pick up on that and actually affirm an appeal. Does that make sense to everybody? I just wondered, maybe now's the time we should see if there's any public comment.
Well, I had a comment.
Oh, sorry, Mr. Almanza. And then I'm sorry, Ms. Moore.
Okay. I mean, these appeals come before the board requesting an action by those appealing to overturn an administrative decision. And it sounds to me like what we're talking about is how does that get presented to the board? And maybe present to the board as, here's the appeal action, here's the background, these are the reasons why this request was denied. And the only option or the only action is whether the board wants to approve the appeal. So I don't know if we really need rules to do that, other than directing staff to present it in a more clear, concise manner.
That could be. Ms. Brownlee?
Well, just in response to that, and I'm sorry if I missed some of the earlier conversation, but I think in terms of noticing the public, it's got to be important that the public knows that we're going to take a definitive action or not. That's got to be, in other words, if we just have something on the item that says, the recommendation is to not approve the district's appeal, but we've got to make sure, I know in my school board days, we would have, major actions, and everything under major actions, the public knew that there was going to be a vote, one way or the other. Now, there might not be enough votes for something to pass, but that there was going to be some action taken, as opposed to when you say, take direction. Lots of times when you give directions to staff, you go back and forth on the interpretation of what the direction is, but at the end of the day, there can be, it can get misconstrued about what the direction really is. So that's not a sort of a definitive thing in my mind. So I think it's just important, first of all, that the public knows that we're going to take an action, and then how we do it. I think, when I say we're going to take an action, there's going to be a motion and a second, and there's either going to be the votes for it or there's not going to be the votes for it.
Right.
And then you're done with it. You've dispensed with it one way or the other.
Right. LUSD.
Eric Bakke with the Los Angeles Unified School District. This has actually been a very good conversation from all perspectives. I first want to admit that I'm probably, our school district is one of those where administrative resolutions have occurred quite frequently. There are a number that you haven't heard about that been brought.
And we thank you, sir.
Well, we thank you too. I think that's the beautiful thing about this, is that we can sit down and collectively figure out. School construction isn't black and white. It doesn't fit in a nice, tidy little box. The program tries to pretend that it's funding, and it doesn't. And so there's going to be circumstances where you got to kind of sit down and try to figure out how to make it work. And many times, more than anyone really knows, those kind of conversations occur. So thank you for that. Our issue today is the conversation about take no action or not having enough votes, therefore staff's recommendation then applies. When there's a disagreement between a school district and OPSC, we're seeking direction from the board. And we need clear direction from the board as to what outcome everyone should follow, because it's really setting the new policy. It's establishing what the basis for any future applications are going forward. So when recently we've had situations where we haven't had vote either way, staff's recommendation applies, well, then I have to ask the question, why do we even have an appeals process? If we're appealing because we disagree with staff's recommendation and this body can't determine what's the appropriate policy, I think that means that we really should have a conversation about that issue so we can establish a policy, because I think there's a disagreement. Because clearly having no votes doesn't mean there's an affirmative that staff's recommendation is correct. That just means we don't have a vote. Before I came here, I researched, and the rules and procedures require that lacking direction in the rules and procedure manual, we default to Masons. Masons is very clear that you have to take a vote. If there's an action brought before the board, a vote has to happen. So that's 6 votes. Whether you agree with the district's appeal or you disagree with the appeal, there needs to be 6 votes.
What happens if there's no motion?
That's the interesting part in Masons. It doesn't specify clearly what you do.
Right.
So the assumption then is you keep working until you get those 6 votes, and it keeps coming back. And to your point, it could be infinity.
Yeah.
But I think
Which is the problem.
which is a problem.
Yeah.
But I think we have a blueprint in the fact that we have so many administrative resolutions before that clearly we just need to sit down in a room and try to figure out how to make it work.
Point
and bring it
of
back.
just, I hope we don't have to call Greg in for this, but we use Masons in the Senate.
Yeah.
if there is no motion on a bill that comes before a committee, the bill dies.
Yes.
I think it's
my point.
analogous here.
That's my
That
point.
if there's
Your
no
appeal dies,
motion
there's no
on an
motion, the appeal
appeal,
dies.
or there aren't
And
6
administrative
votes for
committee
the appeal,
action,
staff stands.
administrative staff recommendation stands.
The only difference I would argue in that respect is that in the legislature, you've got a bill that someone's trying to pass. I'm failing at coming up with the words and how to make the difference. Someone is trying to pass a bill that they want to see a positive outcome, and I get that. You know, if it doesn't get the votes, it fails. I can see that. But here, we're dealing with interpretations of the regulations. And I think that's where it's different. What we're doing is OPSC has an interpretation of the regulation. I, as a school district, have an interpretation of the regulation and why I think I should either be funded or not funded or whatever the circumstances are. We're seeking direction from the board to determine which interpretation is correct for the determination of the regulation. With respect to the legislation, well, no votes, you need 6 votes to pass. I just think there's a difference between the way that the regulations are structured and why we're here. If we agreed in the interpretation, we wouldn't have appeals.
But I think, though, sometimes is, if it were that clear that it was just interpretive, then it would be dealt with attorneys. And it's not just interpretive. It's what do you want to fund? I mean, is it okay to fund the pool instead of the solar panels? Is it okay to fund a library when it wasn't approved upon? I mean, some of that stuff is not interpretation. It's action of what happened. And I think that a lot of the appeals actually fall into that category. I think staff, when it's that gray in the regulations, they look to ways to make it work. I think is the other stuff that comes before is that it's stuff that they can't make it fit into the box. And so to me, an action is required if we're going to overrule staff. And I go back to you, Senator, and your point is very well taken, is we follow the rules, and the last line is the Senate rules. Yeah. That's what we have as a catch-all. If we disagree on everything else, at the end of the line is the Senate rules. And the Senate rules, much like the Assembly rules, is failure to have a motion or fail to have a second, your bill dies. Your issue dies. Your decision-making dies. And that's what this body does. And so when folks sit on a board and they take an action, lack of an action is also an action in my mind.
Well, just a couple of points. Many of the appeals that are coming forward, I mean, we've had numerous attorneys represent the school districts because I know, and I mean, LA's got one that we're still working on. It's almost 3 years old, and we have an attorney involved with, and OPSC has an attorney. So, I mean, there's the level of interpretation of the regulation exists, and it's consistent with a lot of the appeals. When I look at Mason's, you know, I don't have a book, but I was able to write down a few of the code sections, regulation sections. You know, it requires that there must be a definitive proposal for consideration, which is what the appeal is. In order for a body to make a determination or a deliberative action, a vote must be taken. And so if you want an action to occur, and that is OPSC to continue in its approach, you have to take a vote.
But the action is on the appeal itself, though. But go ahead. I'm sorry.
No, I was going to say.
Okay.
I'm sorry. I disagree with the interpretation of Mason's right here. An action has already been taken. We have delegated that authority administratively to the staff of OPSC. And so an action is taken. What you're trying to do is saying that you need an action to overturn an action is taken. Therefore, you need affirmative amount of votes to do that. You're saying in a vacuum, in a proposition put up there, you have to make an action one way or the other. But the action is already taken, and that is the staff ruling of what administratively they did. In order to overturn that, that's when you need the 6 votes on it. So that interpretation is wrong. Secondly, if we put this in the rules, we don't have to worry about that anyway. But the bottom line is I think that's what the difference is. Administratively, 99% of the stuff is done by our authority given to staff to make those decisions based on the rules and regulations that we have interpreted over the years and set in place, so those actions are taken. This appeal is an attempt to overcome an action that was taken, and therefore that's when you need affirmative action to overturn the first action. It's not in a vacuum. There's already been a history of that.
Mr. Almanza and Ms. Brownlee.
Okay.
Okay.
You made my point.
Oh, that's good.
That was quick.
My question is just, are we comparing apples and apples here? I hear what the senator said about the Senate rules, but we're talking about an appeal process here. So I'm just wondering, in the Senate rules, there's one thing about a bill, if there's no motion, the bill dies. Are there any instances within the Senate where you're hearing an appeal and the rule might be different? And I don't know the answer to the question. No?
Not in a legislative committee that I can think of.
No, okay.
So this is different. It's simply that Masons was cited. So that's why we're trying to clarify Masons. Oh, Ms. Moore?
Well, as an alternative, and I know we're discussing this, so I'm just putting it out, at the State Board of Education on waivers, which have some similarity, they're appeals to the State Board of Education. They come under that there must be an action taken, and in fact, if the action of the board is not taken, it defaults actually to the requester of the waiver, to the school district. So in this case, we're talking about the default, and I hope I'm expressing that right, defaults to the staff's actions in a State Board of Education item that's asking to waive a certain education code section. It defaults to the requester if there's no action by the State Board of Education. Now that's provided by I believe provided by Education Code, so it's prescribed, but it is as has been presented here. As we're considering rules, we can consider rules, and then the default is to Masons if we don't have a rule on that particular situation. It's going to default to Masons. So it's an alternative, and I think that's what folks are asking for consideration of is an action one way or the other, and we're and that's what we're discussing.
We're actually more prescriptive than that. We go through Masons and the default is Senate rules.
Okay.
And if you did that, I mean, you would basically invite everyone to appeal every decision, and a lot of times it's based on denial, based on law. So there may be other things such as interpretation of law or rule of committee. You start defaulting on that, we're going to be open up for lawsuits completely. I think that's definitely not a way to go.
I think that, there's a good reason why there's an appeal process in the State Allocation Board. And, obviously, if we're looking at an appeal and the regulations are so crystal clear, I don't think, any of us are going to rule and not take the rules and regulations that are crystal clear and not follow that. We're all concerned about precedent and that. I think it's where the difficulty comes is when it's not that black and white. And I think the reason why we have an appeals process is because you can't create, these regulations and have the regulations meet every single situation that there is. It's just impossible to do so. And so when in the right scenario, when the appeal is being processed, that means the regulations aren't clear. It's not black and white, and we have to sort of make a determination or ruling, in that moment, which is in many times trying to have the debate of what the interpretation is, or creating our own interpretation at that, kind of at that moment in time. So I'm not sure that I'm solving the situation.
Okay, I'm going to actually call for a motion. Would somebody make a motion? We've all talked about this for quite a while.
I forgot if it's B or C at this point, but basically for a lack of affirmative action on the board by the simple majority, the previous administrative decision stands.
Okay. Or could we say that a motion that, number one, the staff will give reasons for the denial and any suggestions they might have regarding policy ambiguity.
I think that's just a board direction to the staff, how they want to present the material. I don't think it has to do with the decision-making process on an appeal, though. But I agree with you on those recommendations, Senator. I just don't think they need to be part of the it's just a format.
Part of the
And we got,
motion.
all asked whatever
Well,
permission.
can we take a minute and ask that? Is it possible to change the format so you provide that information moving forward?
Yeah, we could certainly work on that.
Okay.
So that way it's really clear on the reasons why we are denying it. So we can definitely lay that out.
So
And
that's
Structurally much better, so.
Okay.
And that it would require 6 votes on the board to approve the appeal.
Like I was going to say, Senator, is majority, because who knows how we, legislature, change the makeup of the board, new members coming off, do we establish a quorum and then 3 people leave? Do you still need 6 votes, or do you want a simple majority of members present and voting after quorum? And that's the big distinction there, is, sometimes we do have people leave early because of other commitments.
Oh, that's true.
How do you want that to go apart there? If you need 6 votes and 2 people are sick when you start off, it may make it more difficult. I'm suggesting that once you establish a quorum, a simple majority of those members voting and present.
I believe it's in statute that it requires 6 votes.
Does it?
Yes, it's 6 votes, so, yeah.
6 votes.
Good try. So that would essentially be option C.
So do we get into any bag leaking issues in not laying out the potential recommendations?
No, we are going to lay them out. I thought,
Well, I mean, the question the premise that we've been functioning before, or at least the way I was told, is that we needed to lay out the recommendations, including deny the request, approve the request, and that's how we got into this trouble. And then I asked the question, well, then leave it blank in terms of recommendation, and that's not so there's no action. So we're clear that no action is an option, and we have met Bagley Keene. So people know that it doesn't come out as a staff recommendation, but it's clear that a no action is one of the options being considered. One of the things that I get into trouble in some of my other boards is when I want to go outside of the potential recommendations. And Kathleen, you remember one of the financing authorities out asking that we do this regulation every 2 years instead of every year. And they said, oh, no, because everybody's expecting this for 1 year. It's like, well, have we ever changed it? No. Can we amend it halfway? Yes. Why can't we do it infinity then? They said, oh, because that's not one of the options listed. So I just want to make sure that we check with council in terms of what are the options for purposes of Bagley Keene.
I guess as a point of discussion as well, I think too, I'd like to think of the audience of the agenda item, which is the particular school district in question, or county office or charter, whoever is bringing forth the appeal, and then the larger audience in general. And I do think that in order to have a good public meeting and a public hearing, that they need to know what they're dealing with. And in order to know what they're dealing with, there should be a recommendation. If the recommendation is to deny the appeal, it's to deny the appeal. If the recommendation is to seek board direction, the recommendation is seek board direction. But I would, for the public to not know what the recommendation is in order to prepare whatever public comment they may have, seems that we're not doing justice to the public process. So I would like to, I hope that part of what we're motioning here is that there is a recommendation of the staff. And I think one of the reasons that we're where we are right now is that one of the times there was take no action, which is a confusing recommendation to the public. So I would like to see that there is a recommendation on that. And is that part of our...
The problem is, though, we get into that of the staff recommendations to deny, and if you don't get 6 votes for that, then we're in limbo, because those are your recommendations.
I think that's what we're discussing now.
And that's why the no action lays it out there in terms of one of the options is to continue to support the staff recommendation. By saying no action, you're basically saying staff recommendation stands. The other option is to grant the appeal, and that way the public knows that those are the 2 options under consideration.
Well, and you can have a disclosure to anybody who appeals, very clear when they fill out the appeal form, that if not affirmative action is taken by the board, the staff recommendation stands. You can have that on top of the agenda.
As long as it's in the narrative someplace, then I think would be
you could
okay.
do just a summary narrative anytime you mention that. But that's why I worded it the way it is. Unless there's an affirmative majority vote with 6 votes, staff recommendations, staff recommendation stands.
Okay.
Madam Chair, the other thing that I wanted to highlight is we do have a process in place now where we notify the school district, I think it's typically within around 70 days after the appeal submitted, of staff's position on that appeal. So we send the district a letter letting them know where we stand on their appeal. We give them an opportunity to respond before we present the item to the board. So the districts are aware of what staff's position is. We do it via a letter to the districts.
Okay. I think Ms. Moore was also concerned with just the precedent-setting quality of appeals, and that
Well,
we
I-
make sure that everybody knew.
Yeah, I think it's good that the school, that particular participant has a letter, but we're doing a public meeting, public process, and I believe that the public is owed that recommendation so that they can be prepared one way or the other, however they may want to address the board. If there's no recommendation, then that leaves confusion, I think, to the public as to what the intent of the staff is, what the intent of, or what the direction of the board might be. But I just think, I think if we I think if we clarify that no action on the recommendation, what I'm hearing is being developed, and I think is the motion, means that it's denied. It's, in essence, goes back to the administrative decision, correct?
Yeah. You just, again, the individual appellates are getting the, the correspondence from the staff. The public will see that on top of any kind of appeals, that unless there's affirmative action by 6 or more votes, whatever wording you want to use, the previous administration action stands. Mm-hmm. It doesn't matter how many options you have. No options. You can seek board direction. You can have 10 different options, but if there's not a positive 6 vote on something, then whatever was decided last time works, or by staff.
Would it make sense to try to do 2 motions? One, I would say to adopt option C, which says that you need to have 6 affirmative votes to approve an appeal, and have a subsequent motion saying that the staff report on appeals will list the reasons for denial and policy options, if any, on which they may wish to seek board direction.
I don't have a problem with taking the first one separately, Madam Chair. I don't know if it needs to be in the rules of how you present a particular issue, though. I would
Well,
take
it is,
the
because
UPS.
They're saying one of the things in the staff report right now is that they would no longer give recommendations. So
No, I think we
No,
give
that,
staff.
this motion is different.
Yeah, no, I think we give staff direction what kind of information you have. And let's take that UPS or Federal Express day late thing. There's no real code to cite. They say the rule is there has to be date marked by the stamp. That's the rule. There is no really legal options, but we're seeking staff direction, and that's why they put it in there. I mean, if it gets appealed, it would be that. But let's make the first one, get that out of the way. I move number C.
you're moving policy C? Is there a second?
I'm not in the committee, I'm just here,
I'm
I'm just visiting.
Okay, is there a second to option C?
I have a question.
Yeah, Mr. Almanzo.
So, option C, isn't that pretty much the way it's done now? No change? Because when the appeal comes before the board, it's either we get 6 votes and approve the appeal, or you don't get 6 votes and you lose the appeal. So it's pretty black and white, right?
It was confusing with the options they put up there, take no action, and then some argued that if you didn't get the 6 votes to take no action, that means nothing happened. So that's what we're trying to clarify. And the wording, I think, is a little bit different than option C that I proposed. But-
Actually, Bagley King is the real.
I mean, it seems like a pretty simple issue that's getting very confusing.
So, just so I understand, option C is a recommendation that will have, as the recommendation of every appeal, approve the district's appeal?
We would change it to option, so the board would have the option to approve the district's appeal.
So-
Because
so-
staff wouldn't recommend that the board approve the district's appeal.
So how is this different from what we do now?
What we do now is we list what it says for A1. As we say, the header is recommendation, and then we list take no action, which would allow staff's recommendation to stand.
Wait, that's not option C, right?
No. What we do now is essentially A1 up there on top of page 6.
So is option C basically point 2 of option A
Yeah.
Yes.
as an option?
Yes.
Yes.
So that's all it really does. It takes away the text of take no action, which allows to, but under Mr. Hagman's, instead of an action, it would just clarify. If you take no action, you sort of do the same thing as we're doing now.
Okay, so that's all that appears on the presentation.
Yeah.
On Mr. Hagman's, but not on option C.
So I'm confused, so bear with me. Once again, by voting for the motion, which says approve option C, on State Allocation Board recommendations on appeal, it will say approve the district's appeal, and we will vote for that.
It will it be as a recommendation or will it be as an
to the
option?
board.
It'll be option to the board, not a recommendation.
It's what's before the board, it's the request.
I think that the recommendation of the staff will be the action that's been taken, and that in the item, they will explain the reasons for denial and the items that Senator Hancock brought up. And their recommendation is that the board deny the appeal, if that's their recommendation. But the option then, the board has the option to approve the district's appeal.
No, because then we're being asked to take a vote on the staff's recommendation, and that's where we get into trouble. We don't get 6 votes on the staff recommendation, we end up in limbo again.
Okay, well, I mean,
If you lay it out as a recommendation, that's
Right.
that's what you got to take action on. Unless you have that recommendation in the text and not on the voting
I
part.
still think if you change the rules, and maybe don't put this in option C, and we're talking about recommending or options, that's what we're talking about, how the report's given to us. But the underlying rule that we put on top of the header is if affirmative action is not taken by the majority of the board of 6 members, the staff's last administrative action stands.
Okay.
So any other option we take from that, we take affirmative action to take. So we put that in front of the header. There is no, I think, gray area that we have to vote to affirm what staff's done or not vote. You know, if no action is taken, the staff
Okay,
thing stands.
I could second that.
Okay, Mr. Duffy, did you want to comment?
Should I use this? Madam Chair, thank you, and members of the subcommittee. And I apologize for being here late. I was at the confirmation hearing for the state architect. The issue, and you spoke to it just a second ago, Mr. Hagman, the issue of an item coming before you, and if there isn't a vote for the appeal, that the appeal fails, I don't think it's always as clear as that. There was an item a couple of months ago that of a district on a seismic item, and it was an appeal to the board for some consideration for funding, although they didn't qualify for financial hardship and they were sort of in a limbo state. It was brought before the board one time and there wasn't a quorum. We had understand that there was general support for this, just talking to members and staff. Came back, so there wasn't a quorum, so they couldn't act on it. It came back to the next meeting, and there was a brief discussion of it, and there was no action on the part of the board to approve it. There was little discussion, and in talking to staff afterwards, basically they said, well, the board took no action, therefore the appeal was denied.
Right.
There was no information given back to the district. Here's some options for you. And the question was really, do you get to come back? No, the answer was the appeal was denied because the board didn't take it up. It seemed to me that considering that an action on the part of the board to say, we're denying this because we don't find any merit in it, really concludes the whole thing. This district, I think, is left in limbo.
Right.
So I think some change in the process to really define we're approving or we're disapproving gives at least closure to it. Because I don't know that the district can't come back.
Can staff send a letter to those who appeal to tell them that their request for to appeal the decision was denied by the board?
That
would take care of it.
Right. That issue actually isn't an appeal, so to say. It's to take in consideration other evidence. So the district it's a different request. It's not an appeal. The district is requesting other consideration because they don't fit within the rules within hardship. So I don't technically consider that an appeal.
Well, the district filled out the appeal form and all that. Your staff did a marvelous job of trying to help the district. Your staff at the end was telling the district it wasn't approved, therefore it's denied. So, and they were very clear in saying the board didn't approve this. If the board didn't approve it, so it means it's denied completely. And I realize that asking for an action on the part of the board to say, okay, we're denying this because we're not agreeing with you, is saying do something that you haven't done before. But at the same time, the issue of appeals has been gradually over the last couple of years, because you have a process now where you have the timelines that go before the staff and the AEO. That process is working itself out and I think resolving issues. But this seems to be something that continues to be unresolved. So we've sent you a letter on this.
So would you feel better if, as the chair, I say, given that there was not 6 votes, your appeal is denied and memorialize the issue?
In essence, I believe that's what occurred. I don't know. I wasn't at the meeting. I wasn't at the hearing, so I didn't hear exactly what you said. You were the chair at the time, but I think that there was still a question on the part of the district. The district wasn't in the room at the time either, but there was a question on the part of the district at the end. Is this over, or do we have a conclusion? So if you did say that, does that mean that they can't ask for a reconsideration of this?
We're done with the issue at that point. I mean, at what point do we continue this for the next meeting and the meeting after that and the meeting after that?
That's why I'm saying if indeed you were to say the light switch is on or off with 6 votes, you either get the appeal, it's on, or 6 votes down, it's off. You don't necessarily have all the detail of what.
Well, but I mean, you end up in this. If we were to go your way and say there's 6 votes that say no, then you would still ask the question, well, can this be taken up again?
Yes.
So whether I give you 6 votes with a no or don't give you 6 votes with a no, you're still going to have the question, going to take it up again?
I misunderstood you. If indeed the 6 votes are no, I think it's definitive. The board has said we understand the appeal. We have 6 members here that are voting no. It's over. And I think that would be a very clear and resounding action on the part of the board. Just like 6 votes yes, saying we're agreeing with what you're asking for.
I think the staff saying no and the board supporting staff by not overruling them should send a message. Pretty clear. 6. So.
Well, the reason I'm looking at it this way is the regulations that you adopt as a board are the board's regulations. They're not your staff's regulations. So you are defending your regulations in taking an action that is a positive action of yes or a definitive action of no. And schooled in schools, as I have been, you exhaust your administrative regulations or your administrative actions and remedies with whatever you do. What I saw with that particular circumstance that I mentioned over the seismic issue, and Lisa's correct, the district was asking for some special consideration, but it was still seen as appeal. It doesn't seem like there's any closure to it. Do they have they exhausted their administrative remedies here? I don't know that they have, because you didn't take any definitive action to say no.
Okay.
You didn't have enough votes, basically.
Well, Madam Chair, Mr. Chair, I think that paragraph ahead of the appeals states it pretty clearly. If we don't have the 6 votes to overtake an action, the last administrative action stands. Now, we as a board can sit there and say, hey, we want some more information, bring it back. We don't have a quorum enough to vote on it. Or even the appellate person may say, hey, I had 2 people that I talked to that were sympathetic, but they're not here today. Mr. Chair, can I put it off to the next SAB board meeting? And we could take an action to postpone it to there. But I think in a lack of that, you default to the previous administrative action. Because it's not like an action hasn't been taken. It's been taken. So we need an action to overturn an action. So if you make that clear, I don't think there'll be a question for anyone's mind.
So a motion
Thank
to
you very
that-
much.
Thank you. A motion to that effect would read, unless an action of the SAB by 6 votes approves the appeal, the last administrative action stands.
Just, I was instead of saying approve
To
an
approve
appeal.
the appeal
or
or.
approve an action, a different action, yeah.
So option C,
Well, no, the
Just
option C
that
is a little
option.
different.
Yeah.
The
Leave that
text that
alone.
you just read works well, I think.
Yeah. That's why I wanted to tweak it a little bit. So that way, if we may take an action of 6 votes to send it back to staff and see if you can work on it a little bit, and bring it back to us in 2 board
Or
meetings.
give them 2 parts of the project that makes sense, the
Yeah.
other part we can't do.
So there may be different things than what's the actual approval of the appeal or nothing at all. There may be something in between we give them direction to do. So that'd be an action by board. If there's not an action, the previous action stands. It could be any kind of action. Say, we don't want to vote on it this week, we'll take it up next month. That's an action. We get 6 votes, we move on.
Okay, so unless there is an action of the board with 6 votes to approve the appeal or another action, the last administrative action stands.
okay.
I just want clarifying on that. If we delay an item to a next board meeting, we have those rules. A district can ask for a delay. There's a period of time. We as board members can ask for a delay. That's outside of this. There would be no action. Is that this other action you're referring to?
I think the chair would entertain a motion. Hey, we're going to put this off for the next SAB board meeting. We're all in favor? Yeah, we get 6 votes. Okay, that is an action that we're taking to do something that replaces the last act.
So the question to Ms. Moore is, we're in the middle of this conversation, and it's clear that the votes aren't there. Can Mr. Almanza say, I'd like to have this item moved to next meeting? That's a
You have to
different
get 6
action?
votes.
If you get 6 votes.
Okay?
Okay, we have in our rules that a school district actually can ask for a board item to be delayed to another board meeting and that is granted at the discretion of, I believe, I'm just paraphrasing, at the discretion of the chair and the vice
That's
chair.
before the hearing, yes.
Before the meeting
Before the
starts,
meeting.
none
the
of this
issue.
would come into
No.
question.
Nope. Right.
Not at all.
But if at the board meeting, and then there are times that a board member, before a board meeting starts, asks for an
Right.
item to be not
Pulled.
brought forward, pulled, and it is announced as pulled by the chair. Again, nothing
Doesn't
nothing
impact-
changes
doesn't
with what our action is here. But if an item is on and is discussed, and a board member
And
then
it's fair
says,
game
I
at
would
that
like
point.
to have this come back, we're saying 6 votes
Correct.
allows for that.
Correct. And that way, I mean, and I've never turned down one myself, even if I disagreed with it, just as a courtesy, because you want to get more information, you want to be informed about it.
And sometimes members are absent who are very, passionate about an issue, so we pull that when we find out that member's not here. I think we've done that for Senator Hancock, I think we've done that for Senator Runner, different folks who have expressed an interest in a particular issue and they're not going to be around. We pull that item at the beginning of the hearing. I just want to make an announcement. There were 6 members here, and it's not a Bagley-Keene violation because A, we're meeting in public. B, we're not making any board decisions. This is our committee that's been duly notified, and the members of the committee are voting, and there's only 4, but there were 5 earlier. I'm not voting, but it's not a full board decision. This still has to go before the board. So somebody raised the issue of Bagley-Keene. This is not a Bagley-Keene. This is quite transparent, public, and you're part of the discourse. So anyhow, just for clarification.
So we got the motion.
So did you second it?
I'll second.
Okay. Could you read the motion back? It's been long.
Thanks a lot. Oh
This is not a test.
All right, I have adopt option C. Unless there is an action with 6 positive votes to approve the appeal or another action, staff's action will stand.
I don't think it was adopt option C.
It's not option C,
No,
just
no,
for-
I'm-
Yeah, it was a D we made up.
Right. Okay, right. See, I stepped out of the room for just a minute.
And then I think we also gave direction that we'd like to see some kind of that clarifying notice on correspondence with appeals and on the agenda, and that we've heard all of us say we recommend as many options and parameters of the law and choices, whatever may be specific for that thing, put in the staff reports.
But that
I don't
wasn't
think,
That wasn't part of the
but that's not
motion.
part of the motion. No, I just
That
think
was the motion.
that's administrative anyway.
In the presentation by staff to sort of give us a kind of a summary of the issues while you cover in the text of the discussion, Senator Hancock has requested that you sort of bullet as the primary reasons why there was an issue and identify regulatory, statutory, or constitutional concerns as to why this doesn't fly. And that way we will identify whether it would require regulatory changes or statutory changes.
Right, or just a policy different interpretation. I thought Ms. Brownlee's example was actually very good.
Yes.
If there had been a shutdown of a government building and a deadline was missed for that reason due to some natural disaster
Federal
or
Express,
whatever,
yeah. Okay.
staff might be uncomfortable overturning a regulation, but the board
Yes, we can.
could do that. That's what we used to refer to as the mercy clause, but we won't go into that now, right? Okay, so the motion as read, please call the roll.
Senator Hancock,
Aye.
Assemblymember Kurt Hagman, Esteban Almanza,
Aye.
Kathleen Moore,
Aye.
and it looks like your motion carries.
Okay, thank you. And we'll leave that, and hopefully we've solved that problem. The next item has to do with subcommittees and working groups. And again, my informal understanding of this was that it came about because somebody wanted work group committee meetings to be webcast. If that's the case, quite frankly, I would like to just send it back to staff and say it's an administrative decision.
Take it out of the chair's budget.
On our working groups?
On whether subcommittees and working groups will be webcast. But this particular one was about working groups, I think.
I think the question was brought forward as far as formulating the agenda of the establishment of the working groups. Who has the ability to establish work groups? I think that's what that was what we understood that wanted to be presented.
Is it currently at the discretion of the chair?
That's my understanding.
Because nothing that there's no action the subgroups or subcommittee working groups can take officially on behalf of the board. All we could do is bring back recommendations to the full board for action.
Right.
So if the chair wants to set up 20 different subgroups to bring recommendations back to the full board, I think that's the prerogative of the chair.
At some point, there was a concern that we we put an agenda item that there was the intent of the chair to create a subcommittee of some sort. And I think Ms. Moore correctly pointed out that there are times that issues come up in the middle of a conversation that we need to address and create a working group. The Department of Defense issue comes up very quickly. We created the working group as a result of a presentation on the spot. And so to put into an agenda item now that I plan on doing a working group on, on Occupy Sacramento actions, presupposes that I'll be able to tell what the hot issues of the day will be.
I actually thought that there was two reasons maybe this came forward. Working groups and subcommittees. Subcommittees are like the Department of Defense. We created a subcommittee at the board meeting with the agreement of the board, and then working groups are another area that has occurred within subcommittees, actually. So, for instance, we have the audit subcommittee. I think Esteban, myself, and Senator Lowenthal are on that committee. And during that committee's deliberations, it became there was the need for greater degree of input, and there was a working group created. And I believe that that was created by the chair of the subcommittee, created this working group that then went out, worked, did their work. I think at the time they did it with the prior assistant executive officer. Now the current executive officer is working with that working group that brought recommendations back to the subcommittee, and the subcommittee brings those recommendations back before the board. And I guess what I was seeing this item, and maybe I came in the middle of the conversation on it, that this was saying how are those, how are the subcommittees formed and how are the working groups formed? Is that the purpose of this item?
Part of the other reason for this item is, can a work group be created without the consent of the majority of the board or a subcommittee? Could it be created outside of the board without the at least 6 members deciding to create the subcommittee, or sorry, a working group, or a subcommittee deciding to create a working group? Can a working group be formed without the full membership or a subcommittee's direction?
Again, my 2 cents worth, since there's no action officially taken on the subcommittee or work group, it's just we're hearing public testimony and we're going to report back to the full committee. I see no problem why the chair can't select, pick, send out anything you want, as long as this publicly knows before that subcommittee meets. You can have a webcast or not webcast, you know, but it should be discretion of the chair, and then everything comes back to the full board anyway, and then we affirm the recommendations or we don't take action at that point.
I agree with you with that, Mr. Hagman. What I would not want to see is where Mr. Almanza gathers a group of 12 people on his own and calls that a working group on behalf of the State Allocation Board and draws people into meetings because he has some sort of agenda that he wants to push forward. I think that if it's, you know, the working group, if they're working at the request, I mean, any group can get together. I mean, Cash gets together and does their thing, and they can invite Bruce and Eric and anybody else they want and have their conversation. That's their call, and if they want to elevate issues to the State Allocation or Implementation Committee, that's fine. But I think for Mr. Almanza then to call a group and call Bill and Juan and Cash and call it that he's creating a working group to resolve this issue on behalf of the board, that causes me pause.
No, but that's why the chair gets to do that in an open meeting where it can be discussed and questioned if there is a question about the motives for working group.
In the Bagley-Keene, and that's kind of what I want to be public about it.
Done in the meeting. I don't think it necessarily has to be agendized. You could put an open agendized for new business on there or something for things that come up. But because the working group is not going to meet right then, they're going to meet in the future, which will be agendized and noticed to the public to attend. And that way, you don't have 12 of us going to the staff and having our own little missions. We still go through the public of the board.
Right. An implementation committee can also be a vehicle for such a working group that want to do that, which is still a public meeting. I would be concerned when, you know, and I know we have a difference of opinion on Bagley-Keene issues. You know, I look to the Department of Justice, who would be defending us in the event of a Bagley-Keene violation, and not necessarily allege counsel's opinion of what constitutes a Bagley-Keene violation. So I'm more conservative on that, and that's why I'm a little bit more jealous of who creates a working group or creates a subcommittee.
So to be clear, then what we're saying at the State Allocation Board level is that the subcommittees of the State Allocation Board are created by the board, and that working groups are created by the board or by the subcommittees of the board. And those are the groups. I mean, I'm not aware of a working group out there that is a board that calls themselves a State Allocation Board group that exists.
But I guess the question is, if the subcommittee, just to pick on you, Ms. Moore, you are the chair right now of the Personnel Committee, and you then decide to have a working group. Would that working group be subject to Bagley-Keene if it involves staff to the members of the board?
Probably.
Can I clarify? Because right now, what the rules and procedures say is pretty much what we're discussing. It says membership of a working group shall be determined by the board or a subcommittee of the board. That part's clear. And then the work group meetings shall be publicly noticed and allow for public comment. It doesn't mention Bagley-Keene, and this has come up in the past in some areas. Maybe we should clarify that. And so I think what we've got here is already what everybody is agreeing is what we want, is that the board or a subcommittee could form a working group. And that's what's in the rules right now.
Okay, so.
But in the open of a SAB board meeting, with the direction of the chair, I mean, generally we say yes, or hey, I don't want to be in that board, so you may not have anybody show up in your committee anyway. But that would be, as long as you did in the open presence of the board, then I don't see any, no conflict.
Right.
It's when it happens outside
And
a
that's
public
the working
board.
group. So back to my comment to Ms. Moore, as the chair of the Personnel Committee, if you then gather staff to the board members as a working group because you want to redefine the duty statement or whatever personnel action that you think is appropriate, would that group then be subject to Bagley-Keene?
I don't know. Are we?
I think so.
It sounds.
And that's my concern.
And that's why you come back to the board. You report it as personnel chair, say, Mr. Chair, I would like to, to start a special select committee on whatever the case may be. We want to meet on this Tuesday, whatever. It gets brought up in front of the board. We take action. They set up the special thing. But now it's always open. So I guess if you had to change the rules, just put it that. And I forgot the two terms we're using here. Subcommittee and working group can only be formed at a full SAB board meeting. It could be at the recommendation of the chair or the.
That's different.
We're saying the
That's
chair of the
different.
subcommittee can form a working group.
Let's
But you
deal
bring it
with
up,
the
you
one that
form
we
it.
know about. I mean, there is one that exists. So there is a subcommittee, an audit subcommittee. That audit subcommittee has a working group. That working group was sanctioned by the chair of the subcommittee. It, as I understand, meets in public and notices its meetings and they're, I don't know, I don't go to them. Do you take public comment?
We do take public comment.
So they take public comment. They recommend to the subcommittee. The subcommittee either takes or does not take any input that they have, as does the whole entire board when it's brought forward a subcommittee recommendation. So is that how we
That's
want
fine,
it to
because
function?
it is public, it is a public meeting. But my concern would be if Mr. Almanza decides that, I think that the overcrowded relief grants are biased towards a particular region of the state, and we ought to change that a little bit and equalize it so the rural communities have an equal shot. And he then gets folks who represent the rural areas as a working group with OPSC and Bill and other folks. I don't think that's appropriate if they just do it in a close back room area. If they want to do it in a public forum at the request of, the chair of the committee on what was the cash management or whatever it is we did, then that's a different story. So I think what the definition of the working group and
I get that.
public forum is my big concern, is transparency.
I think also because there are legislative members here, there are administrative members here, there are Department of Education members, and we go about doing our work as well, and we seek guidance on that work. So I may want to bring together a group of folks to talk about an issue, but I'm not representing the State Allocation Board. I'm representing that that's an issue. It may be one that we would deal with as a State Allocation Board at some point, but that we're bringing together a group to discuss that under the auspices of the Department of Education. The Department of General Services might have something similar. Those are not sanctioned by the State Allocation Board. They are sanctioned by the office that you work for. Right. So those, and there may be some, there could be some issues that are discussed there that ultimately become legislative issues or State Allocation Board issues or not. But they're not official meetings of the State Allocation Board, nor its members.
But it would be subject to Bagley-Keene if your group included staff from members of the board.
Not if I'm not talking about a state, not if I'm
Well, if you're discussing an issue related to,
Well, for instance, we have a leadership
The
team
state.
that meets, that are leaders of the agencies. We don't notice that meeting, and we don't sanction it under the State Allocation Board. We sanction it under our agency roles that we're,
Does the agenda or the items discussed then end up as agenda items on the State Allocation Board? So I mean, for instance, if you were to have a meeting, if you called a meeting under the Superintendent of Public Instruction, and in that meeting you asked Mr. Almanza to come in as the DGS representative, and you invite Senator Lowenthal and Ms. Brownlee as the Education Committee chairs, and you invite other folks who are, you invite finance as the money people into this thing, and you start talking about school facility financing and the critical aspects and how the state and how we should be creating a program to maximize the bond money and so forth. I mean, those are issues that will be before the State Allocation Board potentially. But if you have this in a conference room without access to the public, that seems to me that you're asking for trouble on the back of the cane, because you're looking at potential agenda
well,
items.
the superintendent of public instruction can bring together any group of individuals that he wants to seek advice from and to hold meetings with. I don't know how that then affects the State Allocation Board. And I think this is a greater conversation. If that's what this item is, trying to get at, I think we have a greater conversation to be had. If I thought the item was about working groups sanctioned by the State Allocation Board and subcommittees sanctioned by the State Allocation Board. As I said, we have an agency group that has been meeting, and we are discussing items between our agencies. I don't think that, does that ultimately affect the State Allocation Board? I don't,
I guess I'm just an advocate for transparency in Bagley Keene, so it's always my backstop.
Well, I'm going to have to reveal my bias. I grew up in local government where the Brown Act made it impossible to caucus, made it impossible for members to talk to each other. And I just wish someday we all had to live with that here. We could never have 2 or 3 gathered together to have an informal conversation about policy matters. So I actually, if anybody wants to talk about this, we should have it as a larger discussion, because there is separation of powers. They're a different agency with an elected head. There's the administration, and frankly, each one of us is elected to meet with our district and to represent our district and to get advice from people. Now, if we're going to talk about, obviously, we're not talking about setting up me declaring a subgroup or a working group or anybody else here doing that. If the discussion is how do we seek informal advice, I would say I have a right to ask Mr. Savage to give me advice because he works for the board members. Maybe I don't have a right to ask the staff for advice. And if that's the case, somebody should clarify that, and we will not ask the staff for advice. We will go talk to members of the public and other people. I mean, I don't quite get where we're going with this, Pedro.
I don't know where this other item came from, but I think all OPSC staff is available to all board members at all times for information.
Madam Chair, I think to clarify the rules and not get into this other stuff right now, if we made it clear that any of the committees or subcommittees are announced and formed at the full board, at least that is transparent to the public. So if the chair wants to set a committee or a subcommittee chair wants to set up a working group to work on a particular issue, at least that is announced, and that way staff's aware, the public's aware, and if there's an actual date and time for that, that should be notified and publicized. Our staff attorney could let us know that we need to publicize and have it out there, and we could get those groups together. As far as individual one-on-one going to the thing, I don't think that's part of the rules, and we're clear to go. But if you do that, then everything's covered.
And I think,
Okay,
So moved.
do we need to add anything to our existing rules?
I don't think so. I think that the question here was webcasting.
That's what I it's like, how far did we go
Yeah.
to make sure?
And we did
Which-
webcast our meeting, the working group meeting yesterday.
Okay. And I think it's going to be based on availability and feasibility and the cost
Yeah.
of it. So,
Okay, so with that clarifying discussion, I think we have completed our agenda, and I would like to thank the members of the committee, and I guess the clarification that we did on appeals will be, that's a good idea, thank you, Vic. Yeah, are there any public comments now on, that we've completed the agenda? Seeing and hearing none. It's been moved that we adjourn. Now, what if we don't get 6 votes? Okay,
Senator, can I?
all in favor? Aye. Opposed? Motion carries. Okay. Yeah, thank you.